All right, welcome back. So in a matter of weeks, the state's Safety, Accountability, Fairness, and Equity Today Act will change the way people are detained when they're accused of committing a crime. Of course, I'm talking about the SAFE-T Act, designed to reform criminal justice for black and brown people so their alleged crimes do not hold them back from achieving their future full potential.
But the critics of the bill say it's unconstitutional, that it's an unconstitutional piece of legislation, and that it puts the public in danger. And joining us now to talk more about this bill is Dan Kirk. He's a former high-ranking prosecutor at the Cook County State's Attorney's Office for nearly 15 years. I want to thank you, first of all, for coming on our show, Dan.
Thanks for having me, Scott and Anita. I'm happy to be here.
Yeah, absolutely. You know, Dan, over the years, I've been in many bond hearings. And, you know the way it works. A person commits a crime, police charge them based on the evidence they have. Then a prosecutor asks the judge to set the bail, and the defendant either posts the bond or remains in jail until they're tried in court. So how is this going to change?
So this so-called SAFE-T Act is one of the most radical rewrites of the criminal justice code in Illinois that we've seen in recent history, in decades, as a matter of fact. And as currently written, it's a blueprint for disaster for public safety in Illinois. There are aspects of the bill that have some merit, but overall, this will change the system because the bail will be eliminated. Cash bail will be eliminated. So in essence, a defendant will either be held in custody until they go to trial, or they'll be released. That's not really the problem. It's not the elimination of the cash bail. It's how it severely limits a judge's discretion in who a judge can hold, even when that person is clearly a danger to the community. And that's the scary proposition about this, and that's the part of it that's screaming out for some amendment.
Yeah, and it's set off a political fire keg. For our viewers, give them an idea, if you will, of some of the types of crimes where after January 1st, a person can no longer be detained.
So that list of crimes is pretty shocking. So I want to prepare your viewers. It includes aggravated robbery, kidnapping, arson, hate crimes, burglary. Somebody breaks into your house and steals your stuff. They can't really be detained except in very limited circumstances. Threatening a public official, intimidating witnesses, and second-degree murder. The list surprises people. People just shake their heads when they learn how long this list is.
Well, Dan, supporters of the law do say that murderers, rapists, sex offenders, and people accused of gun crimes, they're still going to be held without bail. So, they're asking what's wrong with reforming what some say is wealth-based incarceration for the rest of these lower offenses.
Well, it's important to note that on those offenses that you mentioned, murder, gun charges, maybe they'll be detained. If the state's attorney chooses to make the argument that they're a danger to the community, but it's not a sure thing. Look, holding murderers and rapists in custody pending trial is a no-brainer, right? But it's the other offenses where people will no longer be held. And I just read the list to you of just some of them. It's pretty shocking, and it clearly creates a new danger to our community, which is already being beaten up on a daily basis. People are just absolutely, fatigued and sick and tired of seeing the daily headlines of the brazenness of criminality, especially in Cook County. And that's just been a result of policy in Cook County. This law spreads this to the rest of the state of Illinois.
There's so many elements to this. I wish we had more time, but talk about the impact the law is going to have on criminal cases when it pertains to victims or those who might have to testify against a defendant.
That's one of the most alarming parts about it. It's going to be very difficult to hold people in custody in many of these cases. So it leaves criminals free to go out and intimidate witnesses or the victims. We already have a massive problem with trying to get people to come forward. That's a big reason why clearance rates in Chicago are so low. This is going to make it exponentially worse, and that's not a good thing for the safety of our communities.
All right. Well, Dan Kirk, definitely appreciate your perspective on this. There are some, like the governor, who are saying that this is really political misinformation as we go into the election season. And there is so much to unpack here. Dan, you're going to stick around. You're going to talk with us at 6:20. We're going to talk about some possible scenarios to give people an idea how this law is going to change, things, under the current law when somebody commits a crime and then the new law. So thank you for sticking around now and then again in our next hour.
Happy to be here.
All right.